The Chair recognizes the gentleman from Idaho, Mr. Labrador.
Mr. Chairman, thank you very much. I wonder if the gentleman from Utah has any other questions.
No.
Okay, thank you. Mr. Undersecretary, thank you for being here today. Thank you for your work. I do have a question and a follow-up a little bit on what the gentleman from Utah was saying. As a lawyer, there was always this saying or this dictum that just because it's legal, it doesn't mean that it's right. And I live my life that way. Just because something is legal, it doesn't always mean that it's right. And your excuse or justification for your actions today has just been that it's legal. Can you name one other program in your budget where you guys decided to take money back that you had authorized or given to anybody?
So there were a number of programs on the USDA side that had a similar challenge where the money had gone out prior to the sequestration order hitting. The difference is in other parts of USDA we have transfer authority, and in the Forest Service we don't.
Okay, so you had transfer authority. Were there any programs under USDA that you actually didn't subject to sequestration, did subject them to sequestration?
I'm not knowledgeable of USDA's entire budget, but sequestration applied across all PPAs.
So, for example, I just heard the gentleman from Pennsylvania say that you guys didn't diminish the funding in training or other areas.
Every budget line was subjected to PPAs. That may mean that specific items within a PPA weren't affected. I don't know the answer to that question, but every PPA was subject to sequestration.
Okay. So if there was a difference of opinion as to whether SRS was subjected to sequestration or not, who was the main advocate for changing it, for gaining, the final decision that you made? Who was the main advocate for that position?
So ultimately we decided a lot of these things in conversation with OMB and USDA. In this case, when it applied to the discretion that was applied to this program, whether we were going to pull back dollars or do it all through Title II, the Secretary was directly involved in those conversations. And
was he the main advocate for that?
He was the main advocate for this two-principled approach, be equitable across states and be as least disruptive as we could be within the law.
And it seems like you failed at both, to be equitable across states and to be fair, but...
We were equitable across states, and we did the best job we could in reducing the disruption.
So if I, as a member of Congress, appropriate a certain amount of money for the Department of Agriculture, and we realized after the fact that that money has been inappropriately transferred to the Department of Agriculture, has there ever been in the history of the Department of Agriculture that we have taken that money back the following year from your budget?
I don't know.
I think the answer is no. We may reduce the budget for the following year, but I don't think we have ever said, and now we're going to make you pay for the amount of money that we gave you the previous year. And I can tell you that that's true of probably every budget that we have ever done. Why would you think that it's equitable to do that to the rural counties of the United States?
So the one piece I would add to this discussion about how much discretion and respectful response to your questions would be, we've got the ADA, the Anti-Deficiency Act, that sits on one side, and if we're deficient, that there are real consequences for us. And so we have to keep asking the question about what's legal, because if we don't ask the questions, we have a statute that's a pretty strong statute that penalizes if we go outside of our budget.
And I understand you asked all those questions, but I just don't understand the reasoning for going after counties once you had made the decision to give them the money. I understand for future reference you should have. You should have said, okay, we're going to apply sequestration for future years. You had a bunch of money in the budget that you could have turned to different things. You could have funded your budget accordingly. But it seems like this decision was mostly made to make the rural counties actually suffer and pay a price. And it's ironic, even though there's bipartisan cooperation here, it's ironic that most of these counties happen to be counties that didn't vote for this administration.
So the decision about the decision we had about discretion was, do we absorb the entire sequestration hit within Title II, or do we spread it across the program? Let me give you an example of what would have happened if we would have just done it in Title II. Oregon's Title II dollars would have gone from $7.3 million to $3.6. and they would have absorbed a larger portion of the sequestration hit than other states. We decided that that wasn't fair, it wasn't equitable, and therefore that's what led us down the path that we chose.
It seems to me that if you had divergent opinions in your department and people of good faith and obviously good skill differed on this opinion, it's a decision that could have just waited for the following year to apply instead of doing it on that year. Thank you very much.
Time of the gentleman has expired.